Hello and welcome to yet another series of our sharing information through our video platforms. My name is Takunda Makombiro, Managing Partner of Sinas Legal Practice. Today I'm going to talk about a very common subject that everyone, I believe, is interested in, and this is the issue of contracts. Now, a contract is basically a legal relationship, a legally binding relationship, that is, that two or more individuals can get into. It has obligations and expectations governed by various legislation or regulations depending on what the contract is for. Contracts, I'll tell you, could be verbal or could be written contracts. But today, our interest should be in written contracts for the simple reason that written contracts have a point of reference. Now, this video is going to be discussing the mere basics, as contracts can be extremely technical and may require much more intervention in terms of assessing, analyzing, and getting in depth into all the detail you may require to know about contracts. So let's get straight into it. What are the basics of a contract? Number one, you must understand the nature or purpose or character of a contract. What do we mean? When we're looking at the character and nature of a contract, we are basically answering the question, what is the contract about? What are you trying to achieve? How do we categorize the contract that you have? So, as an example, a contract could be an employment contract. The moment we have given the suffix to the name contract, we understand what we are expecting to find within the contract itself. Now, at the stage of the nature of the contract, we must also understand the legal implications of that particular contract. Now, contracts in terms of legality can have what we call common law legality and what we call statutory legality. I'll not go in depth on that because I promised that this will be very basic. Now, the second thing that we need to look at is the capacity to contract. So that is issue number two. When we are talking about capacity to contract, we are now looking at the parties who are getting into the contract or the individuals who are getting into the contract. Capacity relates to the legal ability to actually get into a legally binding relationship. So capacity comes in various forms. Capacity may be in the form of age. Are you of the requisite age to get into a particular contract? So minors or individuals below the age of 18 have restrictions to contract on their own. They may need their legal guardian or a curator appointed by the court to represent their interests should there be need for them to get into a contract in the first place. Capacity may also relate to your mental state. Don't you have a mental restriction? You could be insane, or you may be facing some form of mental incapacity that will invalidate your ability to enter into a particular contract. So it's very important that at the stage that a contract is being drawn up or the execution of the contract is meant to be achieved, we must ensure that the individuals entering into that contract have the capacity mentally to get into the contract. The contract may also relate to the character of the individuals involved. Now at law, we have what we call natural persons. Those are the human beings that can breathe, and those are the natural individuals. We also have artificial persons. These are recognized in law as your companies. It could be your common law universitas. It could be an association that is regulated under specific areas or bodies of law. Now, if you are contracting with an artificial person, that could be a company or any other institution with proper legal personality, you need to ensure that that company is appropriately represented, because artificial persons obviously act through natural persons. So if you're contracting with a company, the natural person who is representing the company must have the authority to represent the company. This usually comes in the form of a board resolution, a company resolution, or a resolution of the executive committee of a particular institution or organization. These things must be ensured that they are done and they are regular in terms of the processes of law, so that you don't end up getting your contract being voided for the simple reason that the person who signed the document was not authorized to do so. The next thing we have when we are looking at the contract, and that is the third point, it's setting out the obligations of the parties to the contract. So we've agreed, we know what our contract is about. We understand that the people have capacity to contract. So we've ticked those boxes. The next thing, and possibly the most important thing, was that is what people want to regulate. What is it that is expected from each party? So this is what we call the obligations. I usually expect and advise that when you are setting out obligations, may they be clear for party A. So if you are preparing a written contract, make sure it actually states party A's obligations. They are listed so that we know that the contract expects party A to do 1, 2, 3, 4, 5 things. The same applies for the party B. It will be easier to refer to the document and say, you were meant to do this, and within this particular timeline. And if you fail, then the reference is there. That is the most important thing. So the obligations should be clearly set out. They should be in as simple language as possible to avoid misinterpretation. They should also be very clear in the sense that they are not ambiguous or they don't have the ability to be interpreted in varying ways. Once the obligations are set out, we know what each party is supposed to do, and it's important to also place timelines for the purpose of clarity and as well as accountability. The next thing that we have to go to, which is critical and is the fourth thing when you are preparing a written contract, is obviously setting out the consequences of breaching the contract. Now, breaching is simply failing to do what you are expected to do by the contract. We've set out that the obligations of the parties must be clear and straightforward, but if a party doesn't perform as expected by the obligations, then there could be a problem. So how do we address those problems? A breach clause is important in a contract because it tells the party whether there is going to be a period of leniency, a period of trying to give an opportunity to rectify the failure to act or the failure to do and perform your obligations as expected by the contract. Or there could be a different way of resolving. Or possibly that's where the end of the road would be for the relationship of the parties. That is spelled out in the breach clause. Now I need to indicate at this stage, we always get a lot of queries to say, if the breach clause doesn't communicate the various alternatives in terms of remedies to parties, does it mean that a party cannot explore certain remedies which are not communicated in that contract? No, that is incorrect. The law is already there to govern relationships of individuals under the heading of contract law. Even if you don't communicate certain remedies within the contract itself, the law has already provided for those, so you can still pursue those remedies even outside of their specific mention in the contract. So you don't have to go to town basically to try and list all possible remedies that one can get. Depending on the nature of your contract, there will certainly be remedies that are available to you. The next thing is now obviously the execution of the contract itself. So that is the fifth thing. The execution portion is where the parties indicate that they are confirming their acceptance of all the contents that are appearing in that contract. So obviously after the contract has been drafted, you take a look at the contract, you communicate your pleasure with the contents by signing the contract itself. Now signatures can be unique scribblings of your name, or you could actually just place your fingerprint or just write your name as it were. But executing the contract has to be signified by the placement of that signature. Additionally, we require or recommend that people also put their initials on each and every page of the document so that there is no potential of fraud where someone can include a portion of a page that was not part of the initial agreement. And at the execution stage, it is also recommended that there be witnesses that sign. These witnesses are pivotal because should there be an incident where the contract may be required to prove that there was an obligation that was meant to be performed or any other thing arising from the contract, the witnesses can come and confirm that indeed these parties agreed to sign this contract and we were present when that was done. Now, these are the basics or the fundamentals of any contract. If you are willing to get into a contract of any nature, it could be with a domestic worker, it could be with your own family or relations, whatever contract you get into, these fundamentals will help you even if you are going to prepare a contract by yourself. However, it is obviously advised that you find a legal representative that can clarify other important details which may relate to a specific contract, because the nature of the contract governs its contents. I hope this has been very helpful. Thank you and see you next time.